in some cases, issued new release dates. In many instances, the revised release date was months or years earlier than the original release date. Advance notice, we would argue, wasn't sufficient to apprise victims and the DAs, many of whom believe that the recalculations appear contrary to the intent of the original sentencing judge. All of your public safety stakeholders have been navigating this very complicated process over the past 4 months. The amendment before you, sections 7 through 12, is the work of months of work and hours of discussion amongst stakeholders. They are meant to provide clarity to the district attorneys, to the defendants, to defendants' counsel, to the Department of Corrections, and to the court about what to do if, frankly, this happens again, as well as to provide a clear hearings process to address the current early releases. Section 7 is what we will loosely call the recapture. This was at the request of the Department of Corrections, is a needed tool to be restored as to what happens when an error is made in recalculation. This is meant to provide a process to the existing ORS 144350 as restrictively narrowed in the recent companion Supreme Court opinions. Section 7 sets up a clear petition process with a hearing, notice to the victim, and counsel for the defendant. I do believe that DOC is in the room today if there are additional technical questions as to this section. Aaron is going to speak briefly on behalf of OJD to Section 9, so I will skip directly to Sections 10 through 12, which directly address the Torres-Lopez opinion and provides instructions on what happens when DOC recalculates a release date. It makes clear that individuals do not get more credit than what they actually served unless specifically ordered by the court. The intent of credit for time served applies to one consecutive sentence unless the court expressly orders differently and intends that that credit applies as duplicative credits. It requires notice of that change to the court, to the district attorney, to the defense, to their counsel, to the crime victim. That notice also includes notice to the defendant about how to challenge that recalculation. And we're glad to take questions. We do have an issue expert in the room if there's additional questions on Torres-Lopez at the end.
Okay. And Chair Kropp, members of the committee, again, for the record, my name is Aaron Knott. I'm the Director of Government Relations and Communications at the Oregon Judicial Department. We are neutral on this package, but there is a piece of it where we're the appropriate technical expert. So again, wanted to give you the opportunity to get any questions answered. So Section 9 on page 11 seeks to address a problem that goes back further than the Torres-Lopez decisions, which is basically when a judgment leaves the courtroom and goes to the Department of Corrections and is interpreted differently than the court or the parties expected. And so there's been a question under existing law as to how to resolve that difference of interpretation. All this does, Section 9, is establish that if there is an ambiguity between the court and the Department of Corrections, where the court can see what they intended is not what is resulting, they have the ability to bring that back to the originating court and modify it to clarify whatever the disconnect is. And I want to be very clear on the record that that is confined to the record from the original sentencing proceeding. The court cannot do anything new. They cannot go outside the intent of the parties from the original sentencing proceeding. I also want to note that many of these recalculations and reinterpretations disadvantage the defendant in terms of not getting credit that they thought they'd get, not getting the deal that they thought they'd get. And given that the overwhelming majority of cases handled within our criminal systems are pleas, that's often leads to them not getting the bargain that they thought they made at the time that they made the decision to make a plea of guilt. So hopefully this fixes that section. I'm open for technical questions on that component.
Members, we also have representatives from the Department of Corrections, including the director, here to answer any questions we have about the credit for time served calculation. Do we have any questions for this panel or for the Department of Corrections? Representative Chaichi.
Thank you. So there are currently 14 people who, even though the Oregon Supreme Court said the state doesn't have the authority to take these people back, are sitting in there waiting for habeas petitions to be filed and granted. If we pass this with the emergency clause, and I know that some of these provisions are going to be later, but I don't know that this is one of them, what happens to the people who are still in DOC custody? Are they going to be treated differently than the people who have been released from DOC custody?
Is that directed at me?
Whoever has the answer.
Chair Crop, Representative Chaichi, that question is not resolved, I think, or resolvable by Section 9. Section 9 governs different interpretations of terminology, doesn't govern rearrest. I think that it's a piece, but the Judicial Department has no position for you on the retroactivity or effective date of that provision. We're neutral on the bill, just here to describe what it does.
Great. Is there somebody else that can help with that question?
Chair Crop, members of the committee, Amanda Dalton about the district attorneys, it may be a better question either for DOC in terms of how it relates to the current pending habeas petitions for those AICs that are actively in custody, and then perhaps the district attorney's issue expert, Brendan Murphy, can speak as to the state's position on trying to take use of the hearings process that is established in the bill that would allow us to come in and argue that with defense represented by counsel as to whether or not the sentence is appropriate and whether or not they've legally completed the sentence that was authorized.
Right, and can you address that when I call you later? Great. And then we'll just address it then. Any other questions for this panel? We're good. Thank you. Steve Wax and Karen Garrison. Is Karen here? Great.
Chair Krupp, Vice Chair Choatson, and members of the committee. My name is Stephen Wax. I currently serve as special counsel for the Oregon Justice Resource Center, where I helped launch the Oregon Innocence Project 11 years ago. And that was after serving as the federal defender for the District of Oregon for 31 years, which followed a stint as a prosecutor in Brooklyn, New York, where I helped put away the son of Sam. I'm here in opposition to sections 7 through 12 of this bill. During my 50-plus years in the legal field, I've been committed to holding our governments accountable and fighting for the rule of law, the foundation for our free and just society. And I've seen firsthand how fragile the rule of law can be and how quickly it can be trampled by government. Most recently, we have been observing problems with intrusion on the rights of Oregonians and other people in the United States by the national administration. I'm here to point out and hope that you will consider the manner in which the executive branch of this great state has been engaging in an unlawful and improper intrusion on the rights of Oregonians who have been serving sentences in our prison system and were released following the Supreme Court's decision in Torres Lopez. While there has not been any violence involved in any of the actions of our executive branch, there is a similarity in the exercise of arbitrary authority. 6 times so far in habeas corpus petitions, the Oregon Supreme Court has stated and reminded the executive branch that there is no authority to seize, reincarcerate, and hold the people whose sentences were recalculated following Torres Lopez and who were released. My office has represented a number of those people, and one of them is here today, Natalia Hernandez, to talk about her situation. There has been political pushback by the district attorneys and by the governor's office on the release of these individuals. And I regret to say that I believe that there has been a narrative presented that is not entirely grounded in reality. One of the things that is overlooked in this bill, as I see it and urge you to look at, is the fact that all of the people who were released have remained subject to the control of the post-prison supervision system. Anyone who was released, who violated the conditions of release, could, would, and should have been subjected to the existing legal structures that define sanctions and create process for handling sanctions. There is no emergency with respect to those people who were released. Now, with respect to the question that was asked about the 14 who remain in custody, 4 new petitions were filed in the past week by the Oregon Justice Resource Center. And some of those, it seems to me, should be applicable to those people who remain in custody. When the Oregon Supreme Court says repeatedly to the Department of Corrections and the Attorney General and the Governor, there is no legal authority, it seems to me that the Attorney General, the Governor, and the Department of Corrections are duty-bound to release forthwith those people. In reading the decisions in the habeas corpus cases that were filed, I found it quite interesting to note that the Supreme Court said, we mean it now, and waive any other proceedings. There's nothing more that's to be said, according to the Supreme Court. Yet the executive branch has said, unless and until we have an order from the Supreme Court specifically naming this person, we're going to hold them. And I find it difficult to understand how they can say that when the Supreme Court has said there is no authority, there has been nothing presented to us. Now, with respect to the sections that would create laws that are applicable back to July 10, I would point out that the doctrines of retroactivity and the ex post facto clause are, in my judgment, not being adequately considered. The effort to apply any changes in the manner in which the Department of Corrections can hold and retrieve people would, I am quite confident, be very quickly attacked as violative of the Constitution, and the powers that are given by this statute to the Department of Corrections to hold people while they create a process. That process will only be applicable to people in many instances who have already been reincarcerated. So they're going to go back into custody if these procedures are followed, because they are given the authority, the judges are given the authority to hold those people. And that seems to me to compound the false narrative of an emergency and not to provide the type of process that should be available for those people who have been released. Last point. It's getting late.
So please,
Yes.
I'm sure I'm gonna get a call in a few minutes to wrap this hearing up, and I'm trying to get through everybody, but yeah, if you could finish up, that'd be great.
The bases on which the courts and the Department of Corrections can act, ambiguity, and a change in interpretation, that gives virtually unfettered discretion to jerk people around, as Ms. Hernandez is going to talk to you about her situation. A change in interpretation is not a mistake. Now, there's a body of law that talks about erroneous mistakes and if there's a detainer present and why a Department of Corrections should have the ability to bring a person back in. A change in the law, a change in an interpretation of the law just should not be in this bill. I urge you to not move forward with this bill, but to take up what is needed as a fix going forward in some of the provisions at the next full session and not push this through because it is, as I see it, fatally flawed. Thank you for your time.
Thank you, Mr. Wax. Karen,
I'll make this quick. I know you guys
can you
are
pull the
behind.
microphone close to you? Thanks.
I'm sorry you guys are running behind, but
It's all right.
Chair and members of the committee, my name is Karen Garrison. I'm here today as a crime victim in state of verse Cowart, and I am testifying in support of HB 4041. From a young age, I was abused and tortured by my offender for nearly 5 years, and the court process itself was long and painful. My case has stretched on for nearly 6 years, which is when it started, with repeated court dates that forced me to relive the abuse again and again. Each delay was re-traumatizing. It's affected my career as a first responder, my marriage, my entire life. It feels like my offender has more rights than I do. Ultimately, the case was resolved through a plea agreement. I accepted the agreement because I thought it would provide certainty and accountability and spare me from enduring a trial. I was present every step of the proceedings and listened carefully when the judge imposed the sentence. The court's ruling was very clear. My offender was sentenced to 12 years in prison for child sex abuse. The judge expressly stated that he would receive credit for 3 years and 3 years only. There was no ambiguity, there was no apology, there was no acknowledgement. That judgment gave me something I needed, certainty. I knew my offender would remain in custody for nearly 9 years. 9 years of safety, 9 years to heal, and 9 years to start planning how to rebuild my life. It has not happened that way. I have had to show up to court again and again since he was arrested. And then in July 2025, the biggest blow, my offender was released 5 years early. I was notified in a voicemail the day after his release, not months in advance. There was no court hearing. No judge reviewed the sentence. No court clarified the judgment. No victim hearing took place. And within days, I saw him less than a mile away from my house. The terror of that moment is hard to describe as a mother. The sentence I relied on, the judgment that justified the long delays, the repeated court appearances, and the re-traumatization was effectively undone by an administrative decision without process and without regard for the victim who trusted the system to protect her. HB 4041 addresses exactly this failure. It authorizes judicial oversight by allowing judges to resolve sentencing ambiguities. It permits the Department of Corrections to return individuals to custody when releases occur due to error rather than the mistakes just standing. And critically, it requires notice to victims when release decisions are reviewed or corrected. So victims are never again left in the dark about decisions that affect their safety. I'm fairly confident my offender, once released, will come for me and my family. That bill is not about punishment, although I think a lot of people need to be held accountable. This is about process, accountability, and safety. And it is about ensuring that plea agreements and court judgments are honored and that victims are treated with the dignity and respect promised by Oregon law. I respectfully urge you to support HB 4041. Thank you for hearing my testimony.
Karen, thank you for being here. Steve, thank you for being here. Is Kevin Neely here?
Chair Krupp, members of the committee, really appreciate you staying late today, particularly for taking Ms. Garrison's testimony. She came up from grants passed today to address you. My name is Kevin Neely. I'm here on behalf of the Oregon Criminal Justice Truth Project, a membership organization, nonprofit composed of retired, largely law enforcement officers and district attorneys. And I'm addressing the fix to the Torres decision. What we saw over the past 8 months didn't begin with malice. It began with an honest misinterpretation of a Supreme Court case. And the result of that, instead of a well-established administrative process addressing these changes in sentences, instead we had a misinterpretation that resulted in chaos. 8 months of chaos, and as you just heard from Ms. Garrison, profoundly impacting victims, offenders, the courts, really everybody across the criminal justice system. And while that failure caused immediate harm, you just heard from Ms. Garrison about that, it also revealed something deeper, a fundamental weakness in the law when sentence calculation errors occur. The existing framework did not clearly require notice, judicial review, or a consistent mechanism to correct mistakes before they affected liberty and safety. That gap allowed a single error to cascade into confusion, emergency litigation, traumatization of victims, and uncertainty for offenders. Today, the committee has heard from one victim about what that experience was like. That testimony is absolutely important, but it's not unique. There are thousands of victims across Oregon who are affected in similar ways. They are not here today, but they are living with the consequences of that breakdown. We work directly with a number of those victims, helping them seek court remedies not to increase punishment, but to restore the lawful sentences and basic due process that they deserve. What victims consistently ask for is predictability, notice, and respect for court orders. The amendments to HB 4041 fix the problem at its source, clarifies the process when errors occur, ensures decisions are resolved in court, requires notice to affected parties, and provides a clear mechanism to correct mistakes before they spiral into chaos. This bill is not a power grab. It's a guardrail, one that protects defendants, victims, and the integrity of Oregon's justice system. I urge your support for 4041, and I would just add, on my way in here, I was talking to Ms. Garrison, and what really struck me is she's tried everything. She's been in front of courtrooms, now she's in front of the legislature. She really doesn't know what to do to protect herself and her family. I really hope we can take action to hopefully bring her that peace of mind she deserves. Thank you.
Thank you. I think these folks are all online. Do we have Amy Young?
Yes, sir. I'm here. Good afternoon, Mr. Chairman, Vice Chairs, and members of the committee. My name is Amy Young. Thank you for the opportunity to address you about my opposition to HB 4041, particularly the credit for time served and DOC recapture parts of the bill. I practice in Medford and have been an attorney for 32 years, mostly criminal defense. The case of Michael McEwen is the best example for my opposition to HB 4041. He was a first-time offender. Drug addiction fueled the two cases I represented him on. His sentences were carefully constructed by myself, the judge, and the state during what we call a judicial settlement conference. Our primary goal was to structure his sentences so he could have the best chance at participating in the prison drug treatment program known as AIP. In Mr. McEwen's judgments, we cited ORS 137370, subsection 4, because it has the specific language DOC required in order for an inmate to receive credit for time served. There was a consensus to include that language in judgments to ensure that inmates receive their credit for time served. That language has been available since 2015. It is not a surprise nor a new issue. If the statute is changed now, there will only be more litigation over what parties meant when they settled the cases. The Department of Corrections recalculation as a result of Torres-Lopez litigation meant that Mr. McEwen had already done more time than he should have. He was released while participating in the AIP program. Department of Corrections released him on July 30th, 2025. He did well after his release from prison. He married, became a father, and got a job. He was in recovery. Despite that, he was arrested in December of 2025. Almost 2 years after our negotiated agreement, the DA filed multiple motions with varying and often contradictory arguments to change Mr. McEwen's judgments. The DA claimed that the credit for time served we specifically put in the judgments was first a Scrivener's error, then an erroneous error, then ambiguous. They lost, and now they want to change the statutes themselves. Where is their accountability? How do I honestly look at my clients in the face and ask them to take responsibility when those in power who do not? If these statutes are changed, there will be a tidal wave of new litigation. It will go on for years. New trials will be requested, and effective assistance at counsel claims will be filed, particularly since defense attorneys relied upon the law that you are suggesting we change. It will go on and on. Defendants were promised something, and the state did not live up to its share of the bargain. Families of victims and defendants alike will suffer. There won't be closure for any of them to move on and make something of their lives. With the Oregon Supreme Court's recent opinions, the law is very clear and no adjustments need to be made. There are guardrails, there are hearings. What is most horrifying is that these new proposals are intended to be retroactive. That means that they could arrest Mr. McEwen again after he has already become a productive member of society. We should be doing better to support people who have turned their lives around and are contributing to society. Mr. McEwen was already unfairly treated and could face even more unjust treatment. Because he was released during his drug treatment program, he won't be able to pick up where he was when he was released. That will increase his sentence due to no fault of his. Please do not allow this injustice to occur. Thank you so much for listening to me.
Thank you, Amy. Do we have Craig Fornick? Craig, are you with us?
Yes,
Go ahead,
yes.
please.
Chair, Vice Chair, member of the committee, thank you for the opportunity. My name is Craig Froelich, and I'm here to oppose sentencing recalculations in HB 4041. The traumatic experience of our family has gone through the last 90 days has been extremely emotional. My son-in-law is Michael McEwen, recently released by a writ of habeas corpus approved by the Oregon Supreme Court. Michael came to live with his uncle when he was 3 years old, but after his uncle committed suicide, he became addicted to drugs and destruction took over his arrest until he was arrested on February 9th, 2023, 3 years ago today. As a first-time offender, Michael realized his mistakes and began to build back his life via the phone with my daughter. Michael became a model inmate, a work program, a food handler's license, and entering the AIP program. He was being rehabilitated in the best way by doing the work. The DOC website showed Michael to finish his sentence October 28, 2025, but the DOC lawfully released Michael on July 30th, 2025, interrupting his drug rehabilitation program. An interstate compact to Idaho allowed Michael a fresh start with his family. But 4 months later, DOC reversed itself, issuing a warrant labeling him an escapee. When the Oregon escape warrant came on December 9th, his Idaho parole officer called him. Michael went in as requested. Ada County Jail put him in medium security for 2 hours of free time for every 30 hours. Michael signed the extradition paperwork the next day, but Oregon DOC did not come get him until 13 days later. Michael was in the same underwear for 9 days. Ada County also didn't continue his prescription for Suboxone and started a 7-day taper, sending him into detox. His doctor now says 6 months is the minimum time allowed, not 7 days. So here we were, getting ready for Christmas, and one of our family members was detoxing in an Idaho County jail because of an Oregon warrant. Michael was clearly in medical distress. Experts call it post-acute withdrawal syndrome, insomnia, muscle aches, chills, headaches, and severe anxiety. After decorating for Christmas, how do we tell our 4-year-old grandson his daddy will be gone working, and not be home for Christmas to open presents, not home for Christmas Eve, not home for Christmas morning? We thought we were done with Michael's incarceration. My daughter couldn't sleep, but still had to work and be a mom. Our family was hanging on by a thread for 49 days. Why does the DOC double counting policy override a legal judgment by a sitting circuit court judge? Who approved this arrest warrant? In my view, you don't need new laws. You need people in power to follow the current laws. This is chaos for Oregon families. More investigation is needed. Therefore, I oppose House Bill 4041. Thank you.
Thank you, Craig. Grant Hartley?
Yes. And Chair Kropp, Vice Chair Wallen, Vice Chair Choatson, members of the committee, my name is Grant Hartley. I'm the Multnomah County Director for Metropolitan Public Defenders. I am testifying in opposition to only Section 3 of 4041 relating to felony elude. First, This bill, this change will have a disparate effect on the Black and Brown communities in Oregon. I am still waiting on the statistics to demonstrate that specifically for this charge from CJC, which I frankly wish were a larger part of this process. But those disparities are clear just by looking at the CJC stop report that shows the disproportionate stops of Black and Brown individuals. Those communities are also the most likely to have a fear of the police that may make them hesitant to stop. There is also a concerning large spectrum of conduct when it comes to elude, the felony elude statute. It could be an individual driving 100 miles an hour down the highway, swerving through traffic, which seems to often be the example used by the proponents of this statute. But it could also be driving a few extra blocks because you're afraid of the police. And yet this proposal treats all felony elude cases the same. An excellent example of really the combination of both the spectrum of conduct and the disparities is in State v. Johnson, a Court of Appeals case from 2025, where the court held the defendant was entitled to a choice of evils jury instruction because she fled the police because of fear of the police. That was a Black woman who went to her son's school to pick him up in her vehicle when she was approached by two officers. They told her that she had a warrant out of Texas. She explained that she had done work to address that warrant and provided them with information. She also asked for a copy of the warrant from the officers, but they told her that when you get to jail, you'll get a copy. The woman felt frightened and threatened by the officers when they refused to believe her. So she backed up and drove away from the officers. She immediately called 911 explaining the situation, and a little while later pulled over when a different officer joined the pursuit. She did not drive recklessly or speed. That woman was charged with felony elude in Washington County for that conduct. She is not unique. There are many other cases like that. There are also many in our community that fear the police like she did and may be hesitant to pull over or wish to merely drive to a place where they feel more safe. That is more true now than ever when people are being stopped and dragged from their vehicle by ICE officers. People are scared and may be hesitant to stop. This is not the time to enhance the punishment for doing so, both from an equity standpoint, but also, as May Lee pointed out, from a fiscal standpoint. A better approach would be to create different degrees of eluding to acknowledge that spectrum of conduct and ensure that more severe sentences are only imposed on those who are actually creating a risk to public safety, not those who are merely acting out of fear. Thank you.
Thank you, Grant. Do we have Natalia or Natalie Hernandez? Welcome.
My name is Natalia Hernandez. Chair Croft, Vice Chair Chosen, Vice Chair Wallen, and members of the committee. My name is Natalia Hernandez, and I'm here to testify in strong opposition of the HB 4041, which includes what is known as the Torres-Lopez fix. I want to briefly share my story so you can understand the very real human impact of this policy. I was lawfully released on August 12, 2025, after my sentence was recalculated. I was released with nothing and nowhere to go. At one point, I even begged them to stay and let me complete my AIP process in order to get myself ready for release. My counselor then stated that I had to be released and that I had to leave. After my release, I did everything in my power to never return to prison. I reunited with family I had never seen in years. I moved out of Salem into a sober living in Milwaukee, Oregon. I got a full-time job manufacturing joint and bone replacements. I attended NA and AA meetings every week, and I voluntarily put myself into treatment because staying sober and building my life was my main priority. I now attend Parrot Creek Treatment Center and have been working hard to build a stable future. I also married my wonderful husband and became pregnant with our son. I am currently 23 weeks pregnant and due in June. I was finally building a life that I could be proud of. Then in November, I received a call saying there was a warrant for my arrest. Related to DOC, I was devastated. I had followed every rule. I had done nothing wrong. I did not understand how this could be happening to me. But I knew I could not run. I turned myself in. While I was incarcerated, my husband worked hard to pay our bills alone. He put money on my books so we could stay in contact. We were supposed to be moving to Alabama to start our new future. But unfortunately, our lives were put on hold. During my incarceration, I did not receive any routine ultrasounds. I had minimum prenatal care, and my release did more damage than good. My re-incarceration did more damage than good. My date changed multiple times with no explanations. Each change terrified me. I lived in constant fear that I would give birth in prison and have my baby taken from my arms. Eventually, the Oregon Supreme Court ruled on my habeas corpus and found that I was being unlawfully incarcerated. Even then, DOC continued to hold me against Supreme Court's order. We filed a contempt of court in action to release me. I was then released on December 24th at 7:30 in the afternoon. When I was finally released, Family Preservation Project came to get me. Without them, I would have nothing or no one to go to. My husband was in Alabama trying to build our future. In addition to this, mediation involving my daughter has been repeatedly pushed out and delayed due to my continuous reincarceration. This repeated disruption has caused serious trauma to my family relationships. It has damaged the relationship between me and my sister and has prolonged my daughter's ability to come home. This instability caused by these repeated incarcerations has made healing, reunification, and family preservation nearly impossible. Today, I am working again and living in sober living. My husband and I have lost so much and we are financially drained. It feels like our lives have been put on hold for no reason and no fault of mine. My family and I now live in constant fear of being sent back to prison again, despite doing everything right. My child should not have to live without his mother, and my husband should not have to live without a wife. My daughter should not be kept from coming home because of policies that allow people to be repeatedly and unlawfully incarcerated. Policies like the Torres-Lopez fix will only cause more harm to families who are trying to do the right thing. Based on my experience, I believe this bill is unjust and will disrupt more lives than it helps. I respectfully urge you to vote no on the House Bill 4041. Thank you for your time and listening to my story.
Thanks, Ms. Hernandez. Thanks for being here. Theodore, do we have you online?
Yes.
Go ahead.
Chair Kropp, Vice Chairs Choatsen and Wallen, members, thank you for the opportunity to speak. My name is Theo Artie Walheim. I am here in my personal capacity of a resident of House District 45, though I work as a public defender at MPD in Washington County. Through that work, I represent and continue to represent Jose Aureliano Sanchez, who is at the heart of the habeas corpus decisions that came out in December. With his permission, I want to just discuss briefly his experience, and it mirrors that which you have already heard. In August of last year, he was told he was being released from DOC due to a new time comp. What he couldn't know was that decision was made by the Department of Corrections, and it would land him in the heart of a fight he never asked for. Despite being a model citizen while out, he was illegally taken back into custody. He was scared and confused, and at the time, even his lawyer didn't have an answer about what was going on. His parents just wanted their son back home for the holidays. After his release, he showed up to court, and he now faces the risk of going back into prison a third time pending the outcome of his appeal. This fear and uncertainty has been extremely hard on him and his family. When he was released, no one ever said this was a mistake. Some staff members from the Department of Corrections from OISC have testified that this was not a mistake and that they only changed their conclusion after the political pressure from the district attorneys and the governor's office came. The original decision to release my client was made based off of counsel from the Department of Justice. The Oregon Supreme Court also made clear that this was not a mistake or an illegal action when he was released, but a lawful decision. Now there's a campaign to change the law to make what was a decision that complied with the law into a mistake. To make these changes retroactive to July 10th, 2025 only confirms this. Because lawyers, judges, and the Department of Corrections misunderstood 137.370 sub 4 following the 2015 amendment does not turn this into a crisis that will almost certainly result in numerous constitutional challenges and significant litigation. I know I will be there to stand up for Mr. Aureliano Lopez if you do. Sanchez, if you do. He did nothing wrong when he was released and deserves not to be a pawn in a political fight. Changing 137.172 will turn a tool designed to fix legitimate errors into a means for district attorneys to change judgments every time an appellate court clarifies a sentencing rule. One of the few things that a defendant can count on while they are serving their sentence is the finality of it. Giving the district attorney's offices a tool that is this ambiguous is unleashing Pandora's box. In the end, all of this is a solution in search of a problem. This will no longer be an issue. The last 6 months of litigation has caused all parties in the criminal justice system to respond and change their practices. If you feel these changes must be made, convene a proper work group. Bring in the subject matter experts like myself and the members from OJRC who have been working on this litigation. Wait and see if there is a need at the next long session before you make any changes. I strongly ask you to not make these changes and not make them retroactive if you do. Thank you.
Thank you. Zach Winston.
Thank you, Chair Krupp. Chair Krupp, Vice Chairs Choatsen and Wallen, and members of the committee, my name is Zach Winston. I'm the Policy Director at the Oregon Justice Resource Center. The OJRC opposes the language in HB 4041 being presented as a Torres-Lopez fix, which is sections 7 through 12 in the -1 amendment. First, in response to Representative Chaichi's question, which I think Steve Wax addressed, but Section 8 in the -1 makes clear that the proponents intend to use this language to reincarcerate everyone who has been released on habeas and keep those still incarcerated in prison. Prior to joining the OJRC, I practiced as a criminal defense attorney in Oregon. I understand that words matter and the importance of ensuring that any language in a pleading, order, or judgment accurately reflected my understanding of the situation and intent of the parties. If language did not reflect my understanding of the intent, I would raise those concerns immediately. I knew that failing to review and address discrepancies in understanding could have significant consequences in the future. I also understood the importance of staying current on new laws that would impact my practice and clients. OCDLA would hold CLEs addressing any new laws that could impact defense attorneys and recommend changes to our practice moving forward. If a new law went into effect, I would modify my practices to address and comply with the new law. I did not feel comfortable pleading ignorance if I got caught not knowing a law was in effect. These basic tenets of lawyering are at the heart of Torres-Lopez's opinion. Despite the narrative that Torres-Lopez was an earth-shattering case that upended everything, Justice James, in the Aureliano Sanchez case, describes what the court actually held in Torres-Lopez. I'm quoting from the concurrence. Torres-Lopez did nothing more than remind the bench and bar and DOC that RS 137.370 sub 4 had been amended in 2015 to give trial courts the authority to order what would amount to double credit in limited circumstances. But the changes in 2015 to ORS 137.370 sub 4 may not have translated to changes in practice by the bench and bar. That is not uncommon. It is the case that sometimes routines of practice do not always keep pace with statutory changes. In light of Torres-Lopez's reminder, however, from this point onward, practitioners and trial courts would be prudent to use caution in employing generic terms like credit for time served or CTS. End quote. The language the Oregon Supreme Court relied on became law more than 10 years ago, and there was a full legislative record made at the time that discussed how the law would operate. Despite this, some practitioners failed to modify their practices, and DOC maintained administrative rules that denied AICs credit that the legislature said judges should have the authority to award. There's no quote-unquote fix needed. Torres-Lopez and subsequent case law has reminded practitioners to be specific and clear in the language they use, and DOC is on notice to apply language in a judgment literally. Any confusion from Torres-Lopez moving forward can be cleared up with CLEs, training, and attentive lawyering. The legislature is being urged to act immediately with minimal stakeholder input, not because a fix is needed, but because the proponents see an opportunity to use a misleading narrative around the Torres-Lopez decision to seize more power with minimal or arguably no guardrails. The OJRC urges the committee to table the Torres-Lopez language for the short session and continue a more robust, inclusive, and well-considered conversation in the interim. Thank you.
Thanks, Zach. Brennan?
Thank you, Chair Krupp, Vice Chair Choatsen, members of the committee, good evening. I will be as brief as I possibly can. Thank you for your time. My name is Brendan Murphy. I represent the Marion County District Attorney's Office. I am the Chief Deputy in the Marion County DA's office, as well as here on behalf of the Oregon District Attorneys Association, who supports the House Bill 4041-1 amendments, specifically in sections 7 through 12. One of the things I just want to start out with is really just acknowledge what a mess. Just what a mess. It's not fair for defendants to be released thinking that their sentence has been changed and is done, to then be brought back in, to then potentially be released, to then potentially be brought back in. And it's potentially not fair for victims to suddenly learn that despite there being an announced sentence in open court of X amount of time, that suddenly now they have to wonder during the entire sentence whether or not that is real, or will DOC be able to recalculate a time that perhaps means something different. So that process of how we should go about ensuring that individuals are serving the appropriate sentence that was imposed by the court, a process to confirm that sounds like it's very necessary. And that's exactly what sections 7 through 12 are meant to do and do. We appreciate the collaboration with our partners, OCDLA, the Judicial Department, around this bill. There was a lot of effort put into this to make sure that we had counsel appointed for individuals if they were to be brought back in, so that they would be able to have their day in court and the court make a determination about what the original sentence was. So I think that's very important to keep in mind. What we're talking about here is the court would be able to make a determination about whether or not DOC's calculation was in line with the original sentencing court's intent. And then, if it's out of line, the court can make the decisions about how that individual goes back into custody. Representative Chaichi, I believe, asked a question that was punted to me towards the very end, and I want to be transparent about that. I think the question was around the emergency clauses, what potentially can happen to the 17 individuals who are still in custody awaiting for mandamus proceedings to occur. And with the emergency clause, Representative, I believe what could happen would be the state or the Department of Corrections under Section 7 could petition the court to make a determination about whether or not they should maintain an incarceration status and go back to DOC, or whether or not they have completed their sentence. Now, that's a narrow analysis by the court. It would be an analysis of two prongs. One, whether or not the original calculation was in line with the sentencing court's intent. And then second, if there's 30 days or more of the sentence remaining, then they would go back into DOC. This isn't a discretionary analysis of the court. The reason for that, even though it sounds like, and this committee has now heard several compelling reasons as to why maybe someone going back into custody could be potentially a concern to members of the community. The reason we picked a hard date is because what we can't have is another sentencing proceeding. We've heard the necessity for finality. And if we were to reopen and have a new sentencing proceeding at some point through an individual's sentence, that's a second sentencing proceeding, which is of significant fiscal impact. It implicates other constitutional rights of both the defendant and victims. So a sentencing proceeding to reevaluate whether or not going into custody is not the best path forward. Instead, what this would do is it would bring an attorney to the individual at issue. That attorney would be able to make arguments like ex post facto arguments, like we've heard referenced here earlier. They'd be able to make constitutional due process arguments challenging the reincarceration, but ultimately the court would be left with a determination about whether or not DOC's calculation was in line with the original sentencing court. So that is that section of the bill. I'm not going to address sections 10 and 11 at an interest of time. That simply just further clarifies so we don't run into this problem in the future. Notice and how to calculate DOC appropriately. So that is clarified. And then section 9 clarifies that a trial court or the sentencing court maintains the right to clarify ambiguous terms of the judgment. And one thing I'd ask this committee to remember is that the vast majority of the time when we deal with ambiguity in judgments, it's the detriment of the defendant. I can count on one hand the number of times where I've reviewed a judgment, a criminal judgment that came out in favor of the state. And honestly, I believe prosecutors have an ethical obligation to fix it if that's the case. If we have a deal with someone that it's X amount of time that they're going to serve, and then the judgment and DOC calculation is reflected differently, I believe that good prosecutors have an obligation to re-raise that before the court and fix that so it's in line with the agreement of the parties. So most of the time when we're talking about reapproaching the court to address ambiguity, it's to the benefit of the defendant so that they can get the benefit of the deal that they negotiated. This is a complicated topic. I'll stop talking in case there are any other questions. I know it's late. Thank you for your time.
Members, any questions? Great. Thank you Brendan. Thanks for being here. Thanks for walking through this. Thank everybody testified. Sheriff McGill, I apologize. I had a hard stop like 15 minutes ago. So if you would like to add your testimony, you can do so in writing if you don't mind.
Yeah, 2 minutes, or I could read it here or submit it.
If you don't mind submitting it, that would be great. Sorry about that.
Thank you.
Yep. Members, with that, I'm going to conclude today's hearing. Conclude the public hearing, and we'll conclude today's hearing.